If you have ever gotten a letter from your homeowners association about the color of your mailbox or the height of your grass, you have probably asked yourself one question: can they actually do that? Let's walk through what an HOA board can and cannot legally do. First, what is an HOA really? When you buy in, you agree to a recorded declaration, usually called the CC&Rs, for covenants, conditions, and restrictions. It works like a contract that runs with the land, binding every owner. The governing documents stack in order of authority: state law, then the CC&Rs, then the bylaws, then the board's own rules. A rule lower in that stack cannot contradict one above it, and nothing can override state or federal law. So where does that power come from? Two places: your state's HOA statute and your community's recorded governing documents. It is real but not unlimited. As a general rule, if neither the declaration nor state law grants the board a specific power, it does not have it. That is why the honest answer to "can my HOA do this" often depends on your state and your community's documents. Here is the big picture. On the left, what a board generally can do: enforce the CC&Rs and reasonable rules, levy assessments and fines, record a lien, and require architectural approval. On the right, what it generally cannot do: enforce rules selectively, fine you for something that was allowed when you did it, exceed the authority in the documents or statute, or ignore open meeting, records, and fair housing laws. Let's take each side with sources. Start with what a board can do. Each of these is a real, legally recognized power. It can enforce the CC&Rs and adopt reasonable rules on parking, paint colors, fences, pets, and rentals. It can levy regular dues and, subject to the documents and state law, special assessments. Where the declaration authorizes it, it can fine violations, typically only after required notice and a hearing. Florida, for example, requires at least 14 days notice and a hearing before a committee. It can record an assessment lien for unpaid amounts, and it can require architectural review of exterior changes. Here is how a violation usually turns into a fine. It starts with an alleged violation of a rule or CC&R. Next, the board sends written notice. Then, in many states, the homeowner gets a hearing before the fine can be imposed. And finally, if it is unresolved, a fine and eventually a lien can follow. In Florida, a single fine under $1,000 cannot by itself become a lien. The point is that fines are usually a process, not an on-the-spot penalty. Now the other side. First, a board cannot enforce the rules selectively. Cracking down on one owner while ignoring the same violation next door can make a rule unenforceable. And it cannot discriminate. The Federal Fair Housing Act makes it unlawful to discriminate in housing based on race, color, national origin, religion, sex, familial status, or disability, and that applies to homeowners associations. Selective enforcement that lines up with a protected class can expose an HOA to fair housing liability. Boards generally also must allow reasonable accommodations, such as an assistance animal, even in a no-pets community. Second, a board cannot overreach. It cannot enforce rules that are unreasonable, arbitrary, or that conflict with the CC&Rs or state law. Courts in states like Florida have held rules must be reasonable. It generally cannot punish you retroactively, fining you for conduct that was permitted when you did it. It cannot amend the CC&Rs or add major new restrictions without the required procedure, which often means an owner vote and recording. And it cannot exceed the authority granted by the documents and the statute. Third, a board cannot ignore transparency and debt collection law. Many states require board meetings to be open to members, with advance notice. Florida's statute and California's Davis-Sterling Act are two examples. Many states also give members the right to inspect and copy the association's official records within a set number of days. And when an HOA turns unpaid dues over to a third-party debt collector or law firm, the Federal Fair Debt Collection Practices Act generally governs how that collector can behave, meaning no abusive or deceptive tactics. These rules vary by state, so check your own. So what is your recourse? Request the governing documents and official records in writing, citing your state's records inspection statute. Attend and speak at open board meetings, and check whether decisions were made with proper notice. Use the internal dispute or appeal process in your CC&Rs. Some states require mediation before a lawsuit, and if you suspect fair housing discrimination, you can file a complaint with HUD or your state agency. For anything serious, a lien, a big fine, a threatened lawsuit, talk to a local HOA attorney. A few takeaways. A board's power is real but bounded. It flows from your state statute and your recorded governing documents and stops there. Most can they do that questions come down to two things. Is the action authorized, and is it applied fairly and through the right process? Keep a paper trail because written requests, the notices you receive, and meeting minutes are your best evidence. And this is a state-by-state area of law, so always confirm the current rules where you live before you act. This video is general education, not legal advice, and laws vary significantly by state. It was researched and produced with AI assistance, including script research, voice, and on-screen graphics, and edited for accuracy before publishing. If you are dealing with a real dispute with your HOA, a fine, a lien, or a discrimination concern, talk to a licensed attorney in your state.